All right, so I'd like to briefly talk about the Cancer Legal Resource Center. We're a program of the Disability Rights Legal Center based in Los Angeles, but we serve people from all over the United States. We use the educational model where we focus on Know Your Rights campaigns, presentations, and webinars. We do have a litigation team at the Disability Rights Legal Center, but the Cancer Legal Resource Center does not provide direct legal advice or representation. We do, however, have an English and Spanish language line that people living with or affected by cancer can call into, and they can ask any legal question that's coming up for them. We'll research their issue and then direct them to information and resources to help them better navigate the issue that they present. So if there's something that we don't get to today, or if you have a specific issue that's coming up, you can feel free to go online at clrcintake.org and just through our website, and you can ask your legal question. We'll do some free research for you, and then we'll contact you with information and resources. Another thing to note is that all of our services are confidential and they're free. One of those free legal resources is our Patient Legal Handbook. We also maintain a library of fact sheets on a variety of cancer-related legal issues on our website, so you can feel free to go to that and gain access to those different handouts to go get some basic information about all sorts of different legal issues. And we also have something called our Patient Legal Handbook. That handbook provides a brief overview of many of the most common issues and questions that people living with cancer and their families have. We have a new version that has recently been created, and we'd like to give a special thanks to our generous sponsors, the American Cancer Society and Break Away from Cancer. If you're a provider and you're interested in receiving copies of our handbook to share with patients, please feel free to submit a bulk order on our website. We also have PDFs of the handbook in English and Spanish available on our website to download for free. The Cancer Legal Resource Center has a number of other webinars scheduled for this year, and we also have many of them up on our YouTube site. This webinar is being recorded, and we'll be putting it up on our YouTube site as well, so you can access it there if you want to come back to any of the issues or if I go through something a little too quickly. Some of the topics that we're going to be talking about will be health insurance options, financial toxicity, and medical marijuana. If you're interested in registering for any of our upcoming webinars, please sign up for our email list or check our website. And then, like I mentioned before, I'm going to leave some time for questions, but you can always ask a question that comes up later on, or something related to housing or any other legal issue through clrcintake.org. We have an online form there. It's usually fastest to do that, and then we will contact you back. It avoids having to play phone tag, but if you need to, you can leave a message by calling us, and we'll give you a call back to go over the intake with you there. So I want to start off by providing a roadmap for our webinar today. First, we're going to start by talking about federal housing laws. And I'm going to be saying this a few times, but keep in mind that housing rights can vary greatly by each state. So we're going to focus on federal housing protections for this webinar since we have folks attending from all over the country. But please remember to check local and state laws for further protections, and you can contact us and we will give you some information about some of those. But that is critically important to do. So after we talk about federal housing laws, we're going to talk about protections for renters, and then finally protections for homeowners. So as we introduce the most common federal laws that give rights to people with disabilities in the housing context, they're also going to work to protect people with disabilities from housing discrimination. And these different laws typically work with each other and cover different providers and different issues. Some of the issues that these laws address include architectural or structural access, effective communication to a renter or tenant, and policies and practices and procedures. It's important to remember that for a person living with cancer, eligibility for each law varies based on how the law defines a person with a disability. Eligibility can also depend on the type of living situation that a person finds himself in. So each law defines disability differently, and often cancer presents very differently in different people, as I'm sure you all know. So therefore, if a law does not specifically list cancer as a protected disability, you'll want to look at whether the effects of a particular diagnosis or treatment meet the definition of disability laid out in the law. Finally, as an important reminder, again, Please remember that additional protections vary by state, so state and local laws should always be considered when understanding what your housing rights are. The federal housing laws that we talk about provide the basic level of protection for people in a housing context, and in many cases, those protections are expanded upon by state and local laws. The Cancer Legal Resource Center has state law information and referrals available throughout the country depending on which state you live in. So if you'd like more information, you can always contact us. So Section 504 of the Rehabilitation Act, the first law that we'd like to talk about, states that no qualified individual with a disability in the United States shall be excluded from, denied the benefits of, or be subjected to discrimination under any program or activity that either receives federal financial assistance or is conducted by an executive agency. So the key there is normally receives federal financial assistance. An individual with a disability under Section 504 is a person who has a physical or mental impairment that substantially limits one or more major life activities. A major life activity could be considered eating, drinking, walking, or breathing, and therefore most people living with cancer typically qualify as disabled in many instances under Section 504 for protections. So some of the different programs that receive federal financial assistance are public or subsidized housing, although a landlord who only accepts Section 8 rental assistance is not subjected to Section 504. So Section 504 both helps to prevent discrimination, and it provides for physical upgrades of certain dwellings in limited circumstances. So the Americans with Disabilities Act is a comprehensive civil rights law for persons with disabilities. Title II of the ADA prohibits discrimination on the basis of disability in all programs, services, or activities provided or made available by public entities, and that's usually state and local governments. This includes housing when the housing is provided or made available by a public entity, regardless of whether the entity receives federal financial assistance. So this applies to housing operated by public housing agencies and housing operated by states or units of local government, such as housing in a state university campus. State and local governments are required to follow specific architectural standards in the new construction and alteration of their buildings. They also must relocate programs or otherwise provide access in inaccessible older buildings and communicate effectively with people who have hearing, vision, or speech disabilities. Public entities are not required to take actions that result in an undue financial and administrative burden. They are required to make reasonable modifications to policies, practices, and procedures where necessary to avoid discrimination unless they can demonstrate that doing so would fundamentally alter the nature of the service, program, or activity being provided. Title III of the ADA prohibits private entities that own, lease, and operate places of public accommodation from discriminating on the basis of disability and requires places of public accommodation and commercial facilities to be designed, constructed, and altered in compliance with established accessibility standards. So public accommodations at housing developments include any public areas that are open to the general public, such as a rental office, not necessarily the entire housing development. Public accommodations would also include places like shelters and social service establishments. So the Fair Housing Act is Title VIII of the Civil Rights Act of 1968, and the Fair Housing Act, as amended in 1988, prohibits housing discrimination in the sale, rental, and financing or zoning of dwellings on the basis of race, color, religion, sex, disability, familial status, and national origin. Disability under the Fair Housing Act includes any physical or mental disability that substantially limits one or more major life activities. One important distinction is that the person with the disability does not need to be the renter or person who signed the lease or mortgage. Any person that's associated with the person that will be living in the unit, such as a caregiver, cannot be discriminated against under the Fair Housing Act. The Fair Housing Act covers private housing, housing that receives federal financial assistance, and state and local government housing. The Act also requires that new multifamily housing with 4 or more units be designed and built to allow access for persons with disabilities. This includes accessible common use areas, doors that are wide enough for wheelchairs, kitchens and bathrooms that allow the person using the wheelchair to maneuver, and other adaptable features within the units. If a landlord's harassing you because they know that you have cancer, under the Fair Housing Act, it's illegal for your landlord to interfere with any of your fair housing rights, whether it's by use of force, threats, or by intimidation. So if a landlord physically hurts you or threatens to do so, call the police immediately. Write down the date and time of the call, who you spoke to, and what the person said. Write down every detail of every incident. And in a lot of property and landlord-tenant laws, that is very key, to write down and keep track of all the details. Keep written correspondence when possible. If your landlord's harassing you in other ways, keep a list of each incident of harassment, include the date, the time, the place of the incident, as well as names, addresses, and the phone numbers of any witnesses. You should then write a letter to the landlord demanding that the harassment stop. If this doesn't work, you may be able to sue a landlord in a small claims court or get a restraining order. However, before doing any of this, you should seek legal advice from a landlord-tenant attorney in your state or a legal aid organization in any of these types of situations. So under the Fair Housing Act, the Americans with Disabilities Act, and Section 504 of the Rehabilitation Act, your landlord might have to make reasonable changes to their rules, policies, practices, and services if they're necessary for you to have an equal opportunity to use and enjoy a dwelling unit or a common space. A reasonable accommodation is a change, exception, or an alteration of a rule, policy, or service that may be necessary for a person with a disability. To demonstrate that the accommodation is necessary, there must be an identifiable link between the person's disability and the accommodation that is being requested. Your landlord may be required to provide a reserved parking space close to ramps or accessible entrances. They might need to meet renters with disabilities at accessible locations to conduct business, or they might need to make an exception to a no pets policy, which we'll talk about later. Your landlord may ask you for medical proof of your need for a reasonable accommodation. However, you're not required to tell them your specific diagnosis. You do need to let them know that your disability requires the reasonable accommodation that you are requesting. A housing provider does not have to provide anything that's requested. It must be reasonable, meaning that if the request fundamentally alters some aspect of the program or the request creates an undue financial or administrative burden, the housing provider may not have to comply with the request. The Fair Housing Act also requires landlords to allow tenants with disabilities to make reasonable access-related modifications to their private living space as well as to common use spaces. A reasonable modification is a structural change that's made to the premises that's necessary for a person with disability to fully use and enjoy the housing. Requests for reasonable accommodations may be made during any stage of the housing process, which includes the application, the tenancy, and to prevent an eviction. But it's important to get a landlord's permission before making any of these changes, and those modifications must be made according to housing codes. A landlord may request proof that a tenant has a disability and that the request for a modification is necessary for them to use and enjoy the living space. Examples of reasonable modifications could include installing ramps and grab bars, widening doorways, or remodeling kitchens and bathrooms for greater accessibility. A landlord's not required to pay for the changes to an individual unit unless the unit doesn't comply with the Fair Housing Act standards and was made available for occupants after March 13, 1991. Landlords can require you to restore interior changes resulting from requests for reasonable modifications when you move out. So that's an important thing to think about. A landlord may, however, be required to modify the use of public and common use areas of buildings such as lobbies, swimming pools, community rooms, and playgrounds in new or renovated housing. So how to ask for an accommodation in a living area. When asking for a reasonable accommodation or modification, you should always submit the request in writing to your landlord. Explain the accommodation or modification that you need in a letter. Attach the supporting medical documents relating to the accommodation or modification you're requesting. And those documents don't need to disclose your specific disabilities or diagnosis, but they do need to make clear that the accommodation you're requesting is related to your disability. Keep a copy of your request letter and any attachments, and send your request letter and any attachments by certified mail, requesting a return receipt to prove that your landlords received the request. So one of the most common questions that we receive related to housing is whether someone needs to continue to pay rent even if they have a cancer diagnosis or they've recently lost their employment. Having a safe place to live is important for everyone, but especially for those who are coping with a cancer diagnosis. Often a cancer diagnosis and treatment will lead to the inability of the patient to work or family members leaving their jobs to take care of a loved one, so this issue occurs all the time. Unfortunately, for many people, the answer to this question is yes. A person is still responsible for a rental payment despite having a sudden loss of income or receiving a serious diagnosis. We're going to talk about some of the ways to mitigate the consequences of being unable to pay rent. For a lot of people, when faced with the decision of choosing what bills to pay, it makes sense to prioritize paying rent or a mortgage over paying for other expenses when possible, since it's hard enough to have a cancer diagnosis without facing homelessness. So it may be more important to pay rent than a medical bill or a credit card bill, and those are extremely difficult decisions to make. So now we're going to talk about what to do if you are having trouble paying rent. And the first thing is to look at your current situation. If a tenant doesn't have a lease with their landlord, they'll need to look to the state laws that would determine what their property rights are. In some cases, a tenant's lease may have expired, such as situations where they've signed a year-long lease but then stayed in the residence over a year and have turned, and then that lease has converted into a month-to-month tenancy. These situations still require providing notice to a landlord before moving out, although the process varies by state, but may also limit a tenant's responsibility for further payments beyond 1 month. If a tenant does have a lease, it's usually best to start by reading through the lease. And even though these are very dense documents, that's where you're going to want to start, because a lease is essentially a contract between a tenant and their landlord. The lease might explain the process of an eviction or what your rights are in the event that someone can't pay a monthly rent. Some cases it can offer additional protections, such as an early termination clause. If a tenant knows in advance that they'll be unable to pay their rent, talking to their landlord immediately to work out an agreement is often the best course of action, depending on the relationship with the landlord. This could include paying the landlord at a later date or paying part of the rent immediately and the rest later. Your landlord's not required to make an agreement with you and is only bound by the terms of your lease. If a renter is unable to make arrangements with their landlord to delay their rent payment, then they should make arrangements to leave the unit as soon as possible, giving the landlord written notice. A renter can be held responsible for paying the rent for a full 30-day notice period, whether or not they're in the unit, and they could face other issues for breaking their lease early, such as paying the remainder of their lease or paying until a landlord finds another tenant. By providing written notice, a tenant is giving the landlord more time to find someone else to move into the unit, or what a court would consider a reasonable time to find a new tenant. So additionally, a landlord may be open to allowing a tenant to assist in finding someone new to take over their lease, thus reducing their liability for paying the remaining rental payments. This may involve the landlord executing a new lease agreement with a new tenant, or having the tenant directly take on an old tenant's lease agreement. So finding a new tenant could still require having them fill out an application and going through a credit check. If a tenant's in a situation where their lease agreement is not voided, it's also important to carefully discuss and document whether the original tenant would still be required to pay should the new tenant stop paying rent or damage the property. Some states, such as Delaware, Maryland, Michigan, Nevada, New Jersey, and New York, allow a tenant to break their lease if they suffer from a qualifying physical disability that requires them to live someplace else. Most laws require tenants to let their landlord know that they'll need to break their lease in writing within a specific time period before they need to move, and that can range from 30 to 60 days. The tenant will likely need to give their landlord proof that they have a qualifying condition that requires them to live someplace else. If a tenant needs to break a lease early because they're unable to pay rent and needs to move out for medical reasons, unfortunately, there's not usually a clause in the lease that allows it to be broken for medical reasons, or a law outside of these 6 states, that allows one to do that. However, it's always good practice to check. If a tenant leaves before the end of the lease, they may be responsible for the remaining rent due, any reasonable expenses the landlord has in finding a new tenant, minus any rent the landlord can collect from a new tenant between the time you leave and the end of the lease term. However, this can vary. The landlord may have a duty to minimize their losses, known as mitigating damages, depending on the state's laws. So evictions, much like property law, are highly state law specific. So again, please check your local laws for additional protections. And this process may change based on different states. A landlord can't forcibly evict a tenant without proper notice. So if a tenant's failed to pay rent, a landlord can use a 3-day or in some states a 5-day notice to pay rent or quit, depending on the state in which you live, unless other arrangements are made. The landlord must provide written notice to the tenant of the default, and the notice must accurately state the amount of rent that's due. If the tenant does not fix the default within a reasonable amount of time, the landlord must file a formal court eviction proceeding. The most important thing to highlight with this process is that if someone does get a 3-day notice, that doesn't mean that they're going to be locked out of their apartment on the 3rd day. And it's usually imperative that they speak with a landlord-tenant attorney as soon as they get the notice, and hopefully much earlier. If a landlord properly serves a 3-day notice because of a failure to pay rent, then the tenant must either pay the full amount of rent that's due or vacate the rental unit by the end of the 3rd day, unless the tenant has a legal basis for not paying the rent. If a tenant decides to pay the rent that's due, it's best to call the landlord or the landlord's agent immediately. Tell them that you intend to pay the amount demanded in the notice if it's correct, and arrange for a time and location where you can deliver the payment to the landlord or agent. A landlord can give a renter the 3-day notice to pay rent or quit, depending on the state in which you live, unless other arrangements are made. If you fail to pay the rent within the 3 days, your landlord can file an unlawful detainer complaint or eviction against you in the local court where the property is located. Your landlord can't lock you out of your apartment or shut down your utilities or other services for your failure to pay that rent. If your landlord kicks you out, you may sue your landlord for committing a self-help eviction, but you may be locked out by the marshal if your landlord wins that case in court. An eviction is the legal process by which a landlord may terminate a tenant's right to remain on a rental property. The court-administered eviction process assures that a tenant has a right to a court hearing if the tenant believes that the landlord has no right to evict a tenant. So the first step is for the landlord to file a complaint or a petition with the local court and pay a small filing fee. The tenant must be served with the court documents. An unlawful detainer action is typically a proceeding which, unlike many civil trials, can move quickly through a court system. However, in some jurisdictions, tenants are entitled to request a jury trial in which a jury determines whether the tenant should be evicted. In an unlawful detainer lawsuit, the court holds a hearing at which the parties can present their evidence and explain their case. You usually have only 5 days to respond in writing to the landlord's complaint. You must respond during this time by filing the correct legal document with the clerk of court in which the lawsuit was filed. In most jurisdictions, once the landlord has filed the required paperwork, a court hearing on the unlawful detainer will be set. In some jurisdictions, the tenant is required to file a written notice or answer. In those jurisdictions, if the answer is not filed, the landlord will prevail without a hearing ever being set. In jurisdictions that do require a hearing, if the tenant does not attend the scheduled court hearing, the landlord will prevail. A landlord might be given a monetary judgment for the amount of money owed for rent, attorney's fees and costs, and may be granted a writ for possession of the premises. If the landlord does prevail, the writ or court order will typically issue a few days after the judgment, still allowing the tenant the opportunity to move voluntarily. Once the writ's issued, it may be executed by local law enforcement officials, such as the sheriff, but it's never executed by a landlord directly, and the landlord must use this court process to evict the tenant. As the short timeline suggests, time is critically important in eviction cases. So if you're facing a possible eviction, it's important to speak with a landlord attorney right away, a landlord-tenant attorney right away. So the law also requires every residential landlord to maintain the rental unit and common areas in a habitable or livable condition, unless the tenant is the person that caused the damage. Habitable means that the rental unit does not have problems that can affect the health and safety of the tenants or reduce the normal use of the premises. A tenant should first inform the landlord about any problems that are existing. One option is to write a letter listing the problems and the amount of the month's rent included with the letter. In your letter, you can warn your landlord that you're requesting repairs and that if they are not completed, you will be moving out because of the conditions. A breach of habitability by a landlord begins when they first get notice of the issue, even if the landlord has not had time to make repairs. There are several other options if the landlord does not make repairs when notified, but before doing any of these, we strongly recommend speaking with an attorney or legal aid organization that is familiar with property rights in your state. The first option that they may recommend that you do is to move out. 30 days is generally a reasonable amount of time for the landlord to make the repairs before the tenant can move out, but Again, check local and state laws. A second option is to bring in inspectors. So if a tenant can't move out, they could potentially call local city code enforcement inspectors or a local health department for inspection of the rental unit. Another option is to make the repairs and deduct them from your rent. After 30 days of giving notice of the problem to a landlord, a tenant may be able to opt to pay for the repairs themselves and deduct the repair costs from the rent by submitting a copy of the bill with the remaining rent due. A tenant can also choose to withhold rent, but it's the court's decision to determine whether the repair is significant enough to allow a tenant to do that. And if not, they can order the tenant to pay the rents that are withheld. This is pretty risky because landlords can evict tenants for non-payment of rent, so a tenant must have a pretty good reason for withholding it. And then finally, a tenant can sue a landlord for damages. If a landlord has been neglecting to properly maintain a home, all residents have the right to vacate a property that's uninhabitable. Broken toilets, faucets, lack of electricity, and unsecured windows or doors can be a danger to a tenant's health and safety, and if the landlord doesn't respond to requests for repair in a reasonable amount of time, tenants can potentially claim the conditions constituted a constructive eviction. Again, speak with a landlord-tenant attorney or legal aid foundation in your state before attempting to terminate a lease in this manner. There's a good chance that this form of lease termination will potentially take the tenants to court, so be sure that all requests for maintenance, notices for an intent to vacate, and any other communication with a landlord are well documented. Dated emails, notes of when phone calls took place, and a log of when the landlord appeared for repairs will help argue this case in court. Again, speaking with an attorney is important because wording on notices and claims of construction eviction can be very complicated. So even if you're just getting someone to help write a letter to a landlord or review the situation, this can greatly assist in avoiding having to owe money on a technicality. So it's important to note that to be eligible for a constructive eviction, the problem leading to the eviction cannot be caused by the tenant. Persons with disabilities may request a reasonable accommodation for any assistance animal, including an emotional support animal under the Fair Housing Act and Section 504. If a landlord has a no pet rule, a person with a disability can request an accommodation in writing, including a note from a doctor or therapist verifying the need for the support animal. A landlord cannot require an applicant or tenant to pay a pet fee or security deposit as a condition of allowing an assistance animal. However, they may ask individuals who have disabilities that are not readily apparent or known to the housing provider to submit reliable documentation of a disability and their disability-related need for an assistance animal. If the disability is readily apparent or known to the housing provider, but the disability-related need for the assistance animal is not, the housing provider may ask the individual to provide documentation of the disability-related need for an assistance animal. One thing that's important to note is that a service or support animal does not have to be registered with any sort of agency. There are a lot of scam artists online that try to sell different types of certifications, so know that you do not need to purchase those items in this situation. For example, a housing provider may ask persons who are seeking a reasonable accommodation for an assistance animal that provides emotional support to provide documentation from a physician, psychiatrist, social worker, or other mental health professional that the animal provides emotional support that alleviates one or more of the identified symptoms or effects of an existing disability. Such documentation is sufficient if it establishes that an individual has a disability and that the animal in question will provide some type of disability-related assistance or emotional support. A service animal may not be excluded based on breed or size. However, a particular animal must not behave in a way that poses a direct threat to the health or safety of others, has a history of such behavior, or is not under control of the handler. So there's currently a conflict between federal law and many state laws regarding medical marijuana. While states like California have legalized medical marijuana several years ago, and then more recently legalized the use of marijuana for recreational purposes, federal law still makes it a federal crime to use marijuana, even if it's for a medical purpose, and even if a state has legalized it. Because marijuana use is still a federal crime, landlords who have a rule against marijuana use in their building have the option to grant an accommodation for medical marijuana, but are not required by fair housing laws to do so. However, a landlord cannot use the federal housing law criminalizing marijuana as a pretext for denying an accommodation or evicting tenants on the basis of a protected characteristics. So they can't use the federal law criminalizing marijuana as a pretext for denying an accommodation or evicting tenants. For example, it would violate fair housing laws for a landlord to evict tenants with disabilities for using marijuana while ignoring marijuana use by other tenants. Marijuana use is still prohibited in federally subsidized housing, like public housing in Section 8. Therefore, new applicants to such housing will be denied if they use marijuana. However, in states where medical marijuana has been legalized under state law, public housing agencies which operate the public housing and Section 8 programs can adopt their own policy to decide on a case-by-case basis whether to evict or terminate housing assistance to already existing residents based on their use of medical marijuana. So if your landlord's threatening to evict you because of your marijuana use, you should still request a reasonable accommodation for the landlord to make an exception for you because of use is related to your disability. Some landlords might be willing to grant this accommodation, particularly if a tenant's use wouldn't interfere with the rights of others. However, if you suspect that the landlord's real reason for trying to evict you is based on a protected characteristic, you can file a housing discrimination complaint on that basis. If you're already an existing resident of a federally subsidized housing program, you should find out your local public housing agency's policy on medical marijuana use. Individuals who believe they have experienced housing discrimination may file a complaint with a local fair housing agency, their state housing authority, or the U.S. Department of Housing and Urban Development. Private nuisance, which occurs in housing situations, is a civil wrong. When analyzing whether or not an act is a nuisance, courts look at the conduct and the level of interference with a person's enjoyment of the premises. So the harm must be substantial, and that means that trivial annoyances won't be considered a nuisance. The standard is normally assessed by an ordinary individual. Therefore, if someone's doing something that most ordinary people wouldn't find problematic, it most likely will not be considered a nuisance. There is an exception to this, though, when someone knows that their neighbor has a particular sensitivity and they choose to continue the nuisance action. So if your neighbor does something maliciously towards you, then a different standard for nuisance may apply. An example of this is if someone knows that you're sensitive to smoke and purposely blows smoke towards your window, there may be a cause of action. However, you'll have to prove that your neighbor had knowledge of this sensitivity and the potential harm that the nuisance would cause. Things such as construction, as long as they're done during business hours, are not normally presumed to be a nuisance. However, nuisance ordinances for construction are city ordinance specific, so check with your municipal government for more information. As a homeowner in a homeowners association, the association may have certain rules that members must abide by. However, this is very contract specific, and you should look to your homeowners agreement for further information. If you live in a duplex or a different type of shared housing space with individually sold units, then there would be no recourse under the Fair Housing Act, but the same nuisance rules in regular capacity would apply. Unlike homeowners associations, condos associations will have specific rules and stipulations about what is and what is not allowed within the condominium complex. So if you've made specific requests regarding a nuisance that have been arbitrarily denied, then there may be a potential for recourse. If you're concerned about protecting yourself or your family members from secondhand smoke, there are some steps that you can take. You can talk with your neighbors about your exposure. You can check your lease or rules of your apartment complex to see if smoking is allowed. You can see if there are laws in your community that apply to secondhand smoke in multi-unit housing. And you can talk with your landlord or property manager or homeowners association about the smoke problem in your apartment, condominium, or home. Your landlord or property manager may try to fix the problem by plugging underneath your door or sealing in cracks in your walls. This may solve the problem temporarily, but most likely not permanently. If you have a medical condition that's made worse by secondhand smoke drifting into your apartment, then federal and state disability laws may help you to address the problem. Depending on the nature of your disability, your landlord may be required to make changes to reduce your exposure. State and federal disability laws are designed to ensure that people with disabilities have an equal opportunity to access and enjoy their homes. If you rent, your landlord or property manager might be required to make those reasonable changes to the rules to accommodate your disability. We have some examples of accommodations that non-smokers could ask for. You could ask your landlord to prohibit smoking in common areas of a building if the smoke is coming from those areas. You could ask to move to a vacant unit in the complex away from the drifting smoke. In that situation, it's not clear how much of the moving and preparation expenses the landlord has to pay. However, the law clearly contemplates that the landlord may have to bear some costs. Your landlord wouldn't be required to evict another tenant in order to create a vacancy, though. You could ask your landlord to prohibit smoking in the apartments and balconies surrounding your unit. This might not be an immediate solution. The landlord might be required to follow a legally prescribed set of steps to change the leases and make those units non-smoking. And so it could take some time before smoking's prohibited there. If you've exhausted all other solutions and the smoke is seriously affecting your health, then you may want to consider just moving to another property. You could ask your landlord or property manager to waive any penalties for breaking your lease because of that. And additionally, there may be different causes of actions depending on your state law, including nuisance, trespass, or battery that may exist that you can look into. So now we're transitioning into sort of the homeowner's rights portion of the presentation. Foreclosure is the legal process through which a lender attempts to recover a debt that's not being paid by taking possession of a loan's collateral, in most cases a house, and selling it. This means that if someone falls behind on their mortgage payments, a lender may be able to repossess their home and then resell it. Foreclosure processes are different in every state, so it's important to learn about your state's foreclosure laws and protections. Generally, mortgage companies start foreclosure processes about 3 to 6 months after the first missed mortgage payment. The U.S. Department of Housing and Urban Development recommends contacting the lender to possibly arrange a repayment plan that would be based upon your current financial situation. However, mortgage companies are not required to work out a new repayment plan. The law governing foreclosures may vary depending on where you live, but the lender usually forecloses on a home using a few steps. When a homeowner is first having financial difficulties, they may begin by missing some mortgage payments. And when this occurs, the loan becomes delinquent or overdue, and the homeowner goes into default. If a borrower is in default, then they should contact their lender right away to try to work out a way to make up the payments they've missed. After being in default for 3 to 6 months, the lender will contact the homeowner to see whether they can pay their debt, and will also file a notice of default with the county recorder's office. The period of time after the notice has been filed, but before the closure is final, is called pre-foreclosure. If the homeowner does not pay the debt or correct the default within a certain amount of time, usually 3 to 9 months, then the lender will choose a day to sell the home and then give the homeowner a notice of sale at an auction. The notice of sale will also be posted on the property. That'll be filed with the county recorder's office, posted online, printed in newspapers. On the day chosen by the lender, the home will be auctioned to the highest bidder, who will then be given the deed to the property, and that's known as the trustee's sale. If no one buys the home at auction, then it becomes what's known as real estate owned, and the lender takes ownership of the home and tries to sell it through a local real estate agency. After the sale date, a borrower may have the right to enter a redemption period in many states. And redemption is a period after a home has already been sold at foreclosure, when a borrower can still reclaim their home. The borrower will need to pay the outstanding mortgage balance and all costs incurred during the foreclosure process, though. State laws vary, so please contact a tenant and landlord, or actually a property attorney, for information about your rights. Foreclosures can cause a credit score to drop more than 100 points and can make it difficult for the borrower to later borrow money, find housing, or even change employment. So if you're facing foreclosure and you don't enter into a forbearance period, a repayment plan, or a loan modification, the following options may have a less damaging impact on your credit score. The first is selling your home. So a homeowner may be able to avoid foreclosure by selling their home and paying off their mortgage. And that's even if the amount they owe their lender is greater than the value of their home. And that's sometimes called a short sale. A lender may agree to let a homeowner make a short sale if they're at least 2 months delinquent in their mortgage payments, are able to sell the house within 3 to 5 months, and meet additional HUD guidelines. If you believe that a sale is your most realistic option, you should speak with your lender and start looking for a buyer as soon as possible. Most lenders will not postpone the foreclosure process to wait for you to find a buyer for your home. Another option is a deed in lieu of foreclosure, and that's an option where a homeowner voluntarily gives the deed for a home to the lender in exchange for the lender releasing the homeowner from a mortgage debt. This option is for those who want to avoid a foreclosure if they can't sell their home through a short sale. It won't allow a borrower to continue living in the home, and it still will likely cause a credit score to drop, but a deed in lieu of foreclosure will not be as damaging to a credit score as would a foreclosure process. If a borrower has good credit, owes their lender less than the value of their home, known as having equity in the home, and a borrower has been consistently making mortgage payments, a homeowner may consider refinancing their mortgage. To refinance a mortgage, a homeowner works with a lender to get a new mortgage to replace the original mortgage. The original mortgage will be paid off, which will allow the second, more favorable loan to be created. And when done correctly, refinancing a mortgage could save large amounts of money in interest and allow you to pay your mortgage off quickly and easily. This option can be risky for people with poor credit scores, however, because they may not be able to qualify for lower interest rates on the second mortgage like they did on their first mortgage. If you're interested in refinancing your mortgage, you can shop around for different lenders and compare rates and terms of mortgage refinancing plans that are available. When you begin this process, it's important to consider what your goals are for refinancing, how much your home is worth, and your current credit score. So when you're comparing mortgage rates and offers, pay special attention to fees. Mortgage refinancing can trigger many hidden fees. For instance, for assistance refinancing, you may consider speaking with a financial counselor or other experienced professional for guidance. If you're having difficulty making payments because of a temporary change in your situation and need short-term relief, a forbearance agreement may be a good option. When you enter into a forbearance agreement with the lender, your lender agrees to allow you to reduce or miss your mortgage payments for a specific amount of time, and that's called a forbearance period, and they agree not to foreclose on your home during that time. You usually have to agree to begin making payments in full at the end of the forbearance period and pay additional money to make up for what you did not pay during that forbearance period. A loan modification is a permanent change to the terms of a mortgage to make it easier for you to keep up with payments. A loan modification could include reducing the interest rate or extending the term of a loan. So for example, if you had a 20-year mortgage and $1,000 payments every month, you might be able to extend the term of your mortgage from 20 to 30 years total, which would reduce your monthly payment by a few $100s per month. The loan modifications that are possible in your situation will depend on the rules of your original mortgage loan agreement. So to be eligible for a loan modification, typically you must show that you cannot make your current payments because of a financial hardship and must complete a trial period to prove that you can afford the new payments after your loan is modified. If you miss more than 4 but less than 12 mortgage payments, you may be able to work with your lender to file a partial claim with HUD for a loan from the Federal Housing Agency Insurance Fund for the total amount of the payments you've missed. However, this is generally only an option if you're able to begin making full payments on your mortgage again. If HUD grants you this loan, it may place a lien on your home until you've paid back the loan in full. If you've missed a few payments because of a temporary hardship, the repayment plan may help you catch up on these payments after you've gotten your finances back in order. So when your lender allows you to set up a repayment plan, they'll total the amount that you owe and divide the debt over a certain number of months. You pay back that amount in addition to your normal payments. After the repayment period's ended, then you return to making your normal payments. If you think that any of these options make sense for your situation, you should contact your lender or your lender's loss mitigation department. Lenders are usually willing to work with you to reduce the burden of your mortgage because it's easier for a lender to collect reduced payments than it is to foreclose on a home. So one way to use the equity in your home is to convert your home equity into cash through a reverse mortgage. A reverse mortgage or a home equity conversion mortgage is a type of loan designed for seniors age 62 or older whose home is their only property, and they either own their home outright or they have very little left to pay on their mortgage. When someone takes out a reverse mortgage, they can receive a loan for up to half the value of their home and may receive this money in monthly payments, a lump sum, or as a line of credit. A reverse mortgage may be appealing because the homeowner does not have to pay the loan back as long as they're living in the home, and because the money you get from the reverse mortgage can be used to pay off debts and improve your quality of life. However, reverse mortgages typically have higher fees and interest rates than other kinds of loans, and a homeowner must continue to maintain their home and pay property taxes. So for example, if a homeowner moves out of their home for more than 12 months, they immediately become responsible for paying back the entire balance of their mortgage to their lender. If you live in your home for the rest of your life, your family or whoever you name to be in charge of your estate will be responsible for paying the reverse mortgage back, the loan, once you pass away. In most cases, this means that your estate will need to sell or auction off to pay back the money you borrowed. This can be especially hard for couples who take out a reverse mortgage but only have one person's name on it. If the spouse who took out the reverse mortgage dies or moves into a nursing home or other facility, the remaining spouse will have to repay the loan immediately. A reverse mortgage usually only makes sense if you don't have any other assets, you think you'll be able to live in your home for the rest of your life, and you don't want to leave your home to children or family members. Some alternatives for taking out a reverse mortgage include taking out a home equity loan or a home equity line of credit. These are loans in which your home is used as collateral to allow you to borrow money. Some people prefer these options because the amount of interest you pay on these loans is tax deductible up to $100,000, and because in most cases you'll still be able to pass your house on to loved ones if you pass away. So, however, if you default on these loans, your lender could still foreclose on your home. A less risky option might be to sell your home and downsize to a smaller home that's easier and less expensive to maintain. If you choose to do this, you could use the money from the sale of your home to buy a new home and potentially have money left over to try to live more comfortably. If it's important for you that your home stays in your family, you could consider selling your home to children or family members as well. Medicaid is a state-run federal program which provides health coverage for people with low incomes, disabilities, seniors, and other groups who may not be able to afford other types of health insurance. It's known by different names in different states, such as Medi-Cal in California. When Medicaid provides long-term care benefits such as in-home support services or nursing home care to people over the age of 55, federal law requires state Medicaid programs to try to recover the cost of these services after the death of the person who is receiving them. Medicaid does this through a process called estate recovery. In the estate recovery process, Medicaid will try to recover money from the estate if the person who was receiving the long-term care benefits will try to recover money from the estate of the person who is receiving the long-term care benefits. So usually the only part of your estate that Medicaid would be able to recover any money from is your home. The process would only potentially happen if you use long-term care services like in-home support or nursing home care, and generally does not affect people who simply use Medicaid for other health care, though rules vary from state to state. If you think that you may need to receive long-term care from Medicaid in the future, it's also important to consult with an attorney to reduce the amount that can be recovered from your estate after your death. Medicaid estate recovery rules vary depending on where a person lives, so an attorney can advise you about what the law is in your state. If you're the child of or are inheriting property from someone who passed away and had received long-term care benefits from Medicaid, that person may receive a notice from Medicaid stating that the person's estate owes Medicaid a specific amount of money and that the state will be placing a lien on the person's home. However, Medicaid will not place a lien on someone's home if the person's spouse, disabled child, or child under the age of 21 is still living there. Similarly, Medicaid cannot place liens on homes if it would cause an undue hardship on surviving family members. If you've been contacted by your state's Medicaid estate recovery program, you should speak with an estate planning or elder law attorney about what options that might exist to be available to you to prevent Medicaid from recovering those expenses. Refinancing is when you apply for a secured loan in order to pay off another different loan secured against the same assets or property. Mortgage refinancing is a new loan that pays off and replaces an old mortgage loan. Since mortgage loans are not typically amended, a refinance mortgage is the easiest means of restructuring mortgage debt. Typically, home refinancing is done when you have a mortgage on your home and apply for a second loan to pay off the first one. While taking the decision to go for the home refinancing option, it's important to first determine whether the amount you save on interest balances with the amount of fees payable during refinancing. The application for a mortgage refinance is similar to what someone experiences when they purchase a home. You consult with a lender, have the home appraised, complete a loan application, and supply the required documentation to verify your income and assets. You do have to pay closing costs, but they should be lower than they were when you purchased the home. When the refinance mortgage funds, the new lender automatically pays off the old mortgage lender, including any prepayment penalties, and transfers any remaining funds to you. The old lender releases its claim on the home, and then the refinance lender files a new one. The Housing Choice Voucher Program is the federal government's program for assisting very low-income families, the elderly, and people who are disabled, and it allows them to afford decent, safe, and sanitary housing in the private market. Since housing assistance is provided on behalf of the family or individual, participants are able to find their own housing. So this includes single-family homes, townhouses, and apartments. The participant is free to choose any housing that meets the requirements of the program and is not limited to units located in subsidized housing projects. Housing choice vouchers are administered locally by public housing agencies. These public housing agencies receive federal funds from the U.S. Department of Housing and Urban Development to administer the voucher program. Public housing agencies may establish local preferences for selecting applicants from their waiting list. So for example, they may give a preference to a family who's homeless or living in substandard housing or paying more than 50% of their income for rent, or for a family that's involuntarily displaced. Families who qualify for any such local preferences move ahead of other families on the list who do not qualify for any preference. Each agency has discretion to establish local preferences to reflect the housing needs and priorities of its particular community. So many major cities have long wait lists for their Section 8 program, and some have even closed these wait lists until further notice because the demand is so big. So that's not always a realistic option for some people because the wait lists are so long. Additionally, local housing authorities may have rent-controlled or income-based rental properties available. These properties are rented out usually very quickly, so it's important to immediately submit paperwork to try to get into these placements. Sometimes it's helpful to go to the local housing authority's website or contact them directly to ask them about potential units and their policies. Often, financial assistance related to cancer is organized by diagnoses, and this can often include rental assistance in different instances. So you can contact the Cancer Legal Resource Center or the American Cancer Society, and we can try to assist you in connecting you to those different organizations. Finally, here are some of the most helpful housing resources that we've worked with. I'm going to open it up for questions now and come back to this slide I'll come back to this slide in a minute once we finish this recording, but I want to have this for people who are on the webinar. Here's our contact information one more time, and I will be going back to the previous slide, so if you want to write any of that information down, you can, and then we will be opening up for just a couple minutes of questions, it looks like. All right, thank you.